subcommittee. We've got two bills on the agenda. We'll start off with House Bill 162. Chairwoman Purcell, welcome. And
thank you, Mr. Chairman and committee members. House Bill 162 was drawn up to clarify legislation that was passed in the 2010 legislative session related to the sex offenders registry. The law as passed is a little bit confusing in the regards that if a person takes a photograph of a minor, that it makes it illegal for that person to take a photograph without the consent of the parents. Whether it be at a school function, church function, or in your home, it would make it illegal for my 15-year-old grandchild to take a picture of her 15-year-old friend without the parents' consent, and possibly at some point be charged with, and it would be a misdemeanor falling through there. So what this bill does is to take the current law, and I believe it would correct it, that we define individual as being that person that is registered with the sex offenders. And that's all that this bill does, is to try to clarify so that there's not going to be a problem with this bill being constitutional.
so what you're trying to do, if I understand, Madam Chair, is that we've got right now, and just a little bit of history and background. Of course, members will recall that last year we went through a significant reform of our sex offender law to update the law in the context of court decisions that had either come down or were in the process of coming down, and I think it made a lot more sense of our system in terms of how we classified different offenders, everything from level 1 offenders to level 3, and there are very big differences between those offenders. However, we always reserve the right to be wrong, and always reserve the right to have missed something. And I take responsibility for that. In an unintentional oversight, what we ended up doing is leaving language in there that criminalized otherwise innocent conduct.
Correct.
Which, of course, is not a good idea. And what's even a worse idea is if we recognize it and then don't fix it. And that's what your bill seeks to do, as I understand it, is to go ahead and fix that unintended oversight, which, if prosecuted, could, of course, be a disaster and criminalize, again, otherwise innocent conduct. Before I get to questions of members, let me go ahead and ask the subcommittee chair. This came out of Crimes Against Persons, is that right? Oh, Crimes Against Children, I'm sorry. Let me ask Subcommittee Chair Setzler to go ahead and give the report of the subcommittee.
Mr. Chairman, we took this up earlier in the week, as you know. It was there was some debate on it, but I think there's some questions that were raised in subcommittee that were found to not be relevant. I think it was a well-intentioned concern, and as I recall, it passed unanimously. Subcommittee. So.
Thank you, Mr. Chairman. Let's go ahead and ask any members of the committee have questions for the author, Mr. Franklin.
Thank you. I remember when we discussed putting in this code section originally, and there was debate then about the unintended consequence of, if you're filming at the school function, the church function of your child. The reason this word on line 17, intentionally, was actually put in there so there would be no unintended consequence, that if you are intentionally filming your grandchild and someone else is in the field of view, you're not intentionally filming that other child, you're only intentionally filming yours. And that was why that word was specifically put in, I believe, by this committee. I don't believe that was in the original draft to clarify that. And so I'm just kind of wondering if, since that we have that language, and if people are being prosecuted nonetheless, do we even need this code section at all?
May I, Mr. Chair?
Sure.
From the prosecutors that have brought this to my attention, they said that they were really afraid that down the road that this would be declared unconstitutional because it did not spell out the code section 42-1-12. So that is the reason that we're bringing it forward here, is to clarify so that there is no if, and buts, but it's clear as we're talking about a sex offender and the registry.
Right. I understand where this bill is going, so that if someone who has been convicted and is out of jail and is on the registry and is at the church function taking a picture of her child at the ballet recital, and there's another child there, this would also prohibit that as well. Is that?
I will leave that to the discretion of.
And it's your bill. I'm asking.
Well, all I'm concerned with is to get it back to the principle of which this bill was passed last year in 2010. And I have spoken with the primary author of that bill, and he too feels that this should be followed through and the code section of clarification be placed there. Hope that answers.
Yeah,
It's
Ms. Franklin,
debated, but that
it's
that
clear that, I
definitely
mean,
answers.
what we're trying to do, obviously, is to address the conduct of individuals who have to be or have requirements under the sex offender registry as opposed to otherwise innocent citizens. And that's, that was a miss, as the chair stated earlier, but, we're not going to miss it a second time. Mr. Pack.
Thank you, Mr. Chairman. Madam Chairwoman, thank you so much for bringing this bill. I had a quick question about when I was reading this version of the bill, and I think this probably got vetted through last year, and I had a question about a little confusion between subsection B when it says it outlaws intentionally photographing someone, and I think the intent was, correct me if I'm wrong, that you don't want to have an accidental somebody who's unintentionally or taking a picture of their daughter or son at a baseball game, and obviously you take a picture of the background, outlawing that. But if you look at C, it has any person who knowingly violates, which my understanding is a term of art that's different from intentionally. So as a prosecutor, I don't know if there was any prosecutions under this code. What is the mens rea required to be proven by the prosecutor to violate this subsection?
Mr. Peck, I'm going to have, after Ms. Purcell is done, ask Mr. Fortner with the Solicitors Association to come forward and address that issue.
Then I'll withdraw it.
Very well. Mr. Sessler.
Mr. Chairman, I can hold my comment till later.
Okay. I see no further questions, Madam Chair. Thank you.
Okay.
Let me ask, just as a follow-up to Mr. Pack's question, it's a good question, Mr. Fortner, if you wouldn't mind coming forward and seeing what you can do to help us, and Madam Chair, you're excused. Thank you. This is Brian Fortner. I'll go ahead and introduce him. He's a great asset to this committee. He's the solicitor of Douglas County. Has been a real asset to the committee, both before I became chair, for sure, and was a tremendous help on many of the criminal justice bills that we've had over the last 10 years.
Thank you, Mr. Chairman. I can tell, just to make sure everybody understands a little bit of background on this, when 571 came through last year, the state of the law prior to the passage of 571 was that you had this provision, but it only applied to individuals required to register as sex offenders. It was in application and being used prior to the passage of 571. And when 571 came before the committee, just inadvertently in the way the bill was laid out, it didn't make that point clear that it applied to registered sex offenders. So I don't think that it was anything anybody ever intended to do from the prosecutors that I've spoken with and from the author of the bill. It's something that we noticed after the session when we began doing our legislative update and saw that, hey, there's more language in here that is needed to clarify this, because our concern was that law has to be as narrow as it can be, and it can't be constitutionally overbroad, and it can't cast its net so wide as to capture otherwise innocent behavior. And there's been a plethora of case law that talks about photographs, and they're protected under the First Amendment and things of that nature. I think the mens rea thing that we've been talking about, and we're talking about intentionally, if I intentionally take a photograph of Representative Atwood sitting right here, and I know Representative Franklin and Ramsey are there as well, well, intending to take that photograph, I think, is the intent that's necessary. I don't think it's that I intend to take only a photograph of Representative Atwood and just happen to capture them because I'm aware of the scenario and what's going on. I think that was the danger in the bill. But I can tell you without a doubt that prior to 571, it was the law that if you were required to register as a sex offender, those are the folks we're concerned about. Those are the predators and the sexual offenders. You couldn't photograph a minor without their permission. When 571 came through, it inadvertently made that apply to everyone rather than just individuals required to register. And that's the state of the law right now.
Thank you, Mr. Fortner. Mr. Setzler.
Thank you, Mr. Chairman. To his point, this was the point I was going to make earlier, that when you've got if you can imagine the field of view you see in a camera, you've got a number of people in there. It's not just the person you're trying to capture; it's the folks that you see in the view of the camera that you're photographing. It's still intentional to push the button of the camera and capture them. That's a very broad. I mean, you're capturing. Because of the way this works and the way this functions as it's drafted, this is a pretty significant restriction on taking photographs. And that's why I think the purpose of this is that it be focused just on those people who were registered sex offenders, because it is a pretty significant restriction. And I think and again, I know we may be belaboring the point, but to Representative Franklin's concern, this is a significant restriction to people's ability to take snap photos, and that's why it's being specifically limited just to this population. So I just, Mr. Chairman, at the appropriate time, I'd like to be recognized to make a motion.
Very well, Mr. Pack.
Have there been any? I see the intent behind the law, obviously, and we certainly want to protect exploitation of minors by people who have been convicted of sexual crimes. Let me ask you about have there been any prosecutions under the statute since it's been enacted last year?
I can't speak for if there have been any in the state. I can tell you that at the conferences for the prosecutors, this has been discussed and was recognized as a potential problem. I've told my local law enforcement about this provision because they had some questions about it as well, and told them that it wouldn't apply in these situations that we've been talking about, as far as taking photographs at functions, for example, a baseball game or at school. And so in Douglas County, nobody's been prosecuted, and I think that this statute as written will ultimately be held unconstitutional unless this is corrected, because it's not the fact that nobody is being prosecuted, is potentially could someone be prosecuted. The first person who's prosecuted, I would assume, would bring that constitutional challenge, and there it is. I think that I'm not aware of anyone prosecuting it as written, prosecuting just people who are taking photographs who are not required to register, but I can't say that it hasn't happened. Not in Douglas County, it hasn't happened for sure, I can tell you that.
Mr. Atwood.
Mr. Chairman, if I could add one thing. Back in my past life, when I was with Office of Investigations with Customs, we did some nationwide operations on pedophiles and on child pornography and that sort of thing. It was very, very common when we went in with search warrants. We followed up our investigations with search warrants, where we would find children cataloged with photographs, and it was 70, 80, 90 that we would find. And so, I support this effort very much.
Thank you. Mr. Fortner, thank you very much. Is there anyone else who would like to be heard on House Bill 162? Seeing that, Mr. Pack, did you have one? Go ahead, Mr. Fortner. Hold on one second. Mr. Pack, you had one quick one.
My apologies, because this is I'm a freshman on this at the House, but it isn't the harm that we're trying to get at, it's actual possession. I'm trying to think about the practical aspects of a prosecutor trying to prosecute under the statute. This law, as it's written, is outlawing the taking of photographs, but what about possession of the photographs? Because I could foresee the defense would be something like, well, I didn't take that picture.
Right.
Then
I think that would be a proof issue for us. For example, everybody here knows, I'm sure there's catalogs in every newspaper that have children pictured in them. A pedophile may want to collect those for his own sexual deviance. I think that's beyond something we could ever capture and criminalize. It's out there. It creeps us out, for lack of a better term, and it concerns us, but it's out there. But this provision is necessary with the registered sex offenders, and I've had a case that I'm currently involved in where there was a registered sex offender, falls under the old law prior to 571, and the individual who was the parent of the children did not know he was a registered sex offender, and allowed him to babysit, didn't give him permission to take photographs, and he took photographs that to other people may be otherwise innocent in appearance. But knowing him and his past, it was the beginning stages of probably grooming them for something much more devious. But the point of the legislation was these people, these predators, these people who have been convicted and required to register, they present an extra danger. And the taking of those photographs is a problem with them. Even if you don't catch them with the photograph, if they're out there near a playground taking a picture and haven't even seen the photograph yet, that taking of that picture is what we're going after. We don't want to wait till they've gotten it developed and now they have the photos. It's that behavior.
I understand, Ms. Fortner. Just for the record, and as much as I would like to get at the harm of this this risk you're trying, I do have some serious reservations about the First Amendment issues that I think you'll probably have to face as prosecutors, and my understanding is probably litigation over this, I think, in Wisconsin right now based on that, and I fully expect probably we'll have to come back and revisit the statute later on.
The First Amendment has been recognized to protect photographs, even historically to protect child pornography at times by our courts when it was possessed and not distributed. The courts, through their analysis at the federal level, the Supreme Court drew some lines and said that yes, we have an interest when it comes to the exploitation of our children and infringing on that First Amendment right. And I think they've done that. I can tell you that as this statute is written now, absolutely, I think without a doubt, we will have those constitutional challenges. I think if we narrow it to who it's meant to apply to, then I think we fall within those arguments of protecting our children that allow for a statute like this. But as it stands now, I think it's definitely going to be litigated, the constitutionality of it.
Thank you, Mr. Chairman.
Yep. Mr. Coomer.
Thank you, Mr. Chairman. As a former prosecutor and a defense attorney, I've handled lots of cases that involved child sex crimes, child pornography, and one of the things I've seen pretty consistently in Georgia courts, in the state system anyway, is when you have someone who's convicted of a sex crime, a child sex crime, there's usually a provision of the sentence that prohibits them from possessing pictures of any children as a part of their sentence. But what happens sometimes is we have people who are prosecuted for sex crimes in a different system or in a different state, and they're still required to register, but they may not have that provision in their sentence. So, would you agree that this section would aid in making sure that people who we don't want to have that kind of material would have an additional impediment to possessing those materials through the code section, even if it's not in their particular sentence?
Representative Coomer, I think you explained it as best it can be explained. I think that is absolutely correct. We do have a lot of people who come here who are required to register because of something they've done in other states under other laws, and they may not have those same exact provisions that we have. But when they come here to the state of Georgia and they're required to register, they're made aware of all of these provisions and expected to abide by them. I think that's an excellent point.
Mr. Franklin.
Thank you. Does it concern you that there's the potential that by making this change that those pedophiles who have not been caught that would have the potential of being prosecuted under the existing code that we're amending will no longer be able to be prosecuted with this bill?
That is a valid concern, and I will tell you as a prosecutor, I want every weapon you can give me to prosecute sex offenders and predators, but I want one that's not going to respectively shoot blanks. I want one that's going to be a real weapon that I can rely on. And I think I want to, as much as I would like to know who these perpetrators are before they perpetrate crimes and stop them, I just don't think that we can legislate around that fact that we can't speculate as to who is or is not a predator. I mean, that behavior is very concerning, so I would submit to the committee that if we saw someone, or if law enforcement or the school saw someone who was not required to register, not otherwise a sex offender, out taking photographs of children in a way repeatedly that concerned someone, they would probably get a criminal trespass warning in order to stay away from that particular area. And so we'd have other avenues to prosecute them. But it's a concern for me, absolutely, that there are child predators out there that we have yet to identify. But I can't tell you that the current law in its current state of existence would help me find them or combat that.
Thank you. Ms. Travis, did you have a concern?
I just wanted to point out that definition of individual means a person who's required to register pursuant to 42.112. Last year in 571, we divided it out because 42-1-15 has restrictions on where people live, and it didn't really make the most sense to have photography be part of that code section. So when we stripped it out, we forgot that the definition of individual was involved, and that's why this problem was created. Just wanted to give a history on this.
Thank you.
It actually has been lost since 2008.
Thank you. Thank you, Mr. Forden. I don't think there's anyone else who wanted to be heard on House Bill 162. With that, what's the pleasure of the committee, Mr. Setzler?
Move to pass.
Moved to pass by Mr. Setzler. Is there a second? There's a second by Mr. Coomer. Any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye.
Aye.
Opposed? The ayes have it. The motion is adopted. Thank you, Madam Chair. Let me call now House Bill 238. House Bill 238, and there's a substitute in your folder. It's LC 294591, S as in Sam. This is the Public Defender Standards Council bill, otherwise known as the Indigent Defense Bill. And to take a giant step back, this is an issue that this committee has dealt with on occasion over the last couple of years. It has spent most of its time over in the other body, but we have looked at it periodically. What I've learned, and let me just back up even further. It's a bill that I've sponsored, and it's a bill that it's a product of a lot of conversation, a lot of meetings, and a lot of learning, frankly, on my part, having to do with this particular issue. I will tell you that, as I said before, it's mostly been focused over in the other body, and by that, I guess what I mean is we inherited that issue over here. And I have come to learn a lot about that system. It's not something that I do every day, and I think it's probably not something that most of us here at this table, attorneys or not, look at every day. But we have two basic issues as it relates to indigent defense, as I've come to learn it, and I'm still learning it. One has to do with governance, and the other has to do with funding. We have funding issues for sure. That's a creature of our recessionary economy. That's not a secret to anyone. And I think our challenge ultimately is to address that directly. And I think I've been pretty clear in that. I don't think we can really have a system that is adequate, efficient, and effective unless it is properly funded. And that is really the ultimate goal of any legislation that we do here on governance. Before any of us, including me, look at members of the administration and members of the legislative leadership from either side of the aisle and say that this is with a proposal on either dedicated funding or some mechanism that may be quasi-dedicated funding, I don't think we can credibly do that, frankly, until we have a system that is efficient and effective and that works. And for whatever reason, and this is not an excuse or an exercise in saying what's wrong and why and pointing fingers, I think it's clear to everyone involved that we have a system right now that is not working as well as it can simply because of the way it is structured legislatively. And that ultimately really is our responsibility as to why something is statutorily working or statutorily not working. And as I alluded to in Chairwoman Purcell's presentation, if we have something that we see needs fixing, we do well to fix it, and shame on us if we don't, or at least make a good faith attempt at it. So the intention behind this bill is to address the governance issue once and for all, and I'll get into the specifics of it in just a second. But the real goal of it, candidly, is that is merely a first step in getting to the much larger issue of funding and getting to a point where we don't have the Attorney General, frankly, over the course of the next decade, running in and out of state and federal courts defending funding adequacy issues. I just don't think that. I don't think anyone agrees that that is a good use of taxpayer resources, time, personnel, and of course money. So that's the end game, so to speak, on this. But we have to go ahead and address governance first. What does the bill do? It's a very straightforward bill. It's not terribly complicated or terribly long, but it does make some core changes that are not seismic by any stretch of the imagination. but they do confer more authority into the director of the agency. And for those new members that we have here, we have a director and we have a public defender standards council, all of whom I think are involved in the issue for the right reasons and deeply care about the system and deeply care about meeting our constitutional responsibilities. But we also have to balance that, of course, with the fact that we have to run an efficient and effective agency. And to this point, and including now in this point, we've had an agency with a lot of shared responsibilities, with very blurry lines about who has responsibility for what, and frankly, who's in charge. Who's in charge? Who decides? What is the policy of the agency? How are we going to handle conflict cases? How are we going to handle hire and fire issues? General, everyday, workaday, operational management responsibilities and accountabilities. And if that doesn't work, then there's no way, regardless of how much money the agency may get in the future from a dedicated funding mechanism or from without, there's no way it can work. So the objective behind this bill is to bring that efficiency and that effectiveness forward and to establish it. It does put more management responsibility and, frankly, accountability in the hands of the director. It takes the local supervisory panels right now, which are 7 people locally in our local circuits, and reduces that number down to 3. Why? From what I understand, let me back up a second even further. When I alluded to earlier in terms of the conversations that I've had with people, these are meetings that I've had over the course of a year or more with interested parties. Who is that? The State Bar, the Association of County Commissioners, ACCG, the Circuit Public Defenders, and anyone else really who wanted to be heard and had an interest and a background on the issue, because I believe in more opinions rather than less. And it's through those conversations that I have winded my way to this bill. And, of course, conversations with the previous administration and with the current administration, because that's extremely relevant, certainly from a budgetary management standpoint. From the previous bill, and I appreciate those conversations very much. They've been very helpful. It truly has been a group effort. This is a bill that is a work in progress. I think it's a pretty solid work product, candidly, but it's something that's ongoing, and we want to get a good ultimate work product, and so there's always room for improvement. I'm the first one to say so. These local supervisory panels are set up in the established law. There are 7 people from these local jurisdictions. And what I came to learn, again, learning from involved parties, is that these local supervisory panels, if they're established at all, either don't meet, don't have regular interaction with their local CPD office, and are not what I would call hands-on and engaged. That's not a criticism of them personally. It's the fact that you're talking basically about volunteer people, people who are volunteering, and it's hard to get people to volunteer to do anything these days, let alone something like this, which is fairly hands-on and fairly engaging. So what we did in the bill is to make those local supervisory panels really leaner and meaner, to go from 7 members of those panels to 3, 3 appointees, 1 an appointee of the governor, 1's an appointee of the chief judge, and 1 is the appointee of the county commission. 3 interested parties who have obviously an interest in how the operation goes. In terms of the workings of the director and the relationship between the director and the Public Defender Standards Council, we've had a situation in the past where there's been a fair amount of, I don't know if I'd call it hostility, but there's just sort of a negative inertia is what I would call it, on the relationship of the director and the council, the hire and fire, who hires, who fires, and there seems to have been stagnation in that operation around that issue on the part of some members of the council, and frankly, very few members of the council. But again, if you don't have an operation where you have a clear line as to who hires whom and who fires whom, then you have a recipe for some real internal conflict. What the law currently says is that the governor, the director serves at the pleasure of the governor. In an effort to, and the council has always, I'm not going to say has always, but certain elements of the council have been very vocal in their desire to go ahead and hire and fire the director. What this proposal, what the substitute proposes to do, is to compel cooperation and collaboration, candidly, between the executive branch and the council. And what it proposes to do is to have the council appoint the director subject to the approval of the governor. And so what that theoretically produces or seeks to compel is a collaboration, and most of all, positive working communication between the administration and the council about who's running the show. I think that may strike you as being intuitively obvious. Well, of course that should be the case, but that's not the case right now, and that's what we're trying to get to. Our circuit public defenders. The bill does provide that the circuit public defenders, the vast, vast, vast majority of whom are doing a good job, will come under the authority of the director in terms of hire and fire. The director will have the ability to set policies, administrative policies, personnel, operational management policies, including how we handle conflict cases throughout the state, including, as per state law, the ability, or the possibility, I should say, of having conflict representation occur between circuits, where there's a conflict within one circuit, assigning that conflict case to the next circuit over, cross-circuit conflict representation, as it's called. The director needs to have the ability to work with the CPDs and to say, look, this is what needs to get done. We can't have the CPDs, and this goes for any operation, whether we're selling widgets or indigent defense. You have to have someone in charge. There has to be accountability for people's actions and also their inactions. The CPDs are doing a fantastic job, but the director needs to be able to go ahead and take actions necessary where, on the rare occasion where there is a CPD who frankly will not be willing to do what's necessary in order to have the system run effectively. Again, that sounds intuitively obvious, but that is not the system that we have now, and that's what the substitute seeks to clear. There are amendments in the bill from in the substitute, and I took amendments from nearly all interested parties, including the CPDs, including the ACCG, and including the State Bar, to make it a better, more workable bill. One of the suggestions that was made by the CPDs, which I thought was an excellent one, and I regret the fact that I didn't think of it myself, was the fact that, okay, if the CPDs are going to come under the authority of the director, certainly we can't, if there's going to be a termination of a CPD, that needs to happen for cause. It can't just be in an at-will standpoint. We can't have a director, whether now or in the future, firing a CPD because they don't like the color of their tie or whatever it may be. If there is going to be a termination, which I would anticipate to be a very, very rare occasion, that must be for cause. That's a critically important component to protect the CPDs from any sort of what I'll call internal abuse. If this, and further along those lines regarding the CPDs, if there is a termination which the CPD feels is wrong, not for cause, there is within the substitute there is a mechanism whereby the CPD can go ahead and appeal that termination to the council, and the council, I believe, by a 2/3 margin, can go ahead and overturn the termination decision of the director. Do I anticipate that ever really being the case as a practical matter? No. But the CPDs need to know that they have protection from an abusive situation, whether in the case of an initial termination or in an appeal to the council. That, from a highlight standpoint, is essentially it. The ACCG gave me some technical amendment suggestions in terms of how we handle the caucusing of the local supervisory panel, what to do in a sole commissioner situation, sole commissioner circuit situation, as opposed to jurisdictions that have multiple or more than one commissioner within a jurisdiction. We incorporated those ideas into the substitute, and I think that is essentially it. We did add a provision in Section 4 that the director will prepare an annual report for us, the General Assembly, the governor, and we also added the Supreme Court. I think the Supreme Court, as the leaders of the judiciary, have an interest in knowing how the operation is running, and there are partners in this type of issue, and they need to be informed about what's going on. And bear with me for just a few moments just to make sure I haven't missed anything of any real significance. One thing I also wanted to point out, I think it's important in this legislation to foster as much as we can the cooperation and collaboration between the director and the council. In Section 8, as I said earlier on line 197, we're vesting with or proposing to vest with the director the operational responsibility, management accountability, etc. That doesn't mean that the council is not relevant. The council is very relevant, to the point where I thought it necessary and appropriate to add language in that where the director, and this is just using the example of a conflict representation, the director shall establish a procedure for providing such legal representation, but mandating that they have input from the council as well. I think any director who is worth his or her salt is going to have that input, seek that input if they're smart. But we wanted to go ahead and just make sure of it by adding that language into the statute. What I've also learned over the course of the last year, and then I'll hush, is that a lot of times things work or not work in a situation such as this, not so much because of the way the law is written, although that's critically important, as we all, I think, realize now, but also comes down to sometimes the personalities that are involved and people's willingness to collaborate and to work well with others. And that's a function of the appointments that are made. It's a function of who the governor appoints, who the speaker appoints, who the lieutenant governor appoints, and so on. And that's why those appointments are so critically important, that it's so important for all those three appointing individuals, to appoint people who know how to collaborate and who have their eyes on the prize, and that is a really, really efficient, effective system, not just now, but a generation from now. The first step on that is governance. The next step is funding. But we have to do governance before we do funding. I'm sorry if I've gone on ad nauseum about that, but I just wanted to make sure that the committee understood my intentions behind it and how we plan to attack it. So with that, Ms. Abdul Salam.
Thank you, Mr. Chairman. Going back to the Circuit Public Defenders and looking at some of the additions and changes, you mentioned earlier that the directors would be, I guess, terminated or admonished at the discretion of the governor. Is that also true for the Circuit Public Defenders, or will it be totally up to the directors?
The hire and fire would vest with the director. Okay. However, under the category of we're all accountable to someone, we can't have anyone not being accountable. We can't have a CPD that looks at the director and says, no, I'm not going to handle this conflict case. We can't have a situation where we have a CPD. Not that this is a perennial condition. It is not. And I want to make sure the CPDs in the audience who are watching this hearing understand that. But on the rare, and I do mean rare, occasion, where you have a truly insubordinate situation, or let's say a CPD who's become personally incapacitated and yet is unwilling to step aside in order for the betterment of the system, I think we have to have a director who can take some sort of action. That said, there have to be checks and balances. CPDs are out there doing a tough job and doing a good job by and large. Okay. There have to be protections for them. So if there is a termination, it must be for cause. That's a critically important component.
I understood that. I just didn't know if the governor had to review.
No, and an appeal. No, he does not. And an appeal to the council if they want to challenge the termination.
One final follow-up.
Sure.
I noticed down at line 159 on page 5. In your earlier statements, you talked about the supervisory council of 7 not really meeting as often as they should, and reducing it to 3. But at the same time, on line 160, you changed the convening from semi-annually to annually. Why is that?
It's to make sure that the meetings actually occur. I figure if a meeting occurs once a year as opposed to twice a year, it's more likely to go ahead and occur. And I think with the 3 people, one being an appointment of the chief judge, one being an appointment of the governor, the other being an appointment of the county commissioner, the county commission, I think it's just more necessity. The fewer the meetings, the better, as long as they actually occur and they're effective.
Thank you.
Okay. Mr. Vice Chair.
Thank you, Mr. Chairman. A couple of points I wanted to raise. On line 121 on page 4, I think we need to clarify where it says the chairperson or sole commissioner of the largest county in the judicial circuit. I think we need to clarify we're talking about, I assume we're talking about largest by population. Is that, or has that been?
It's a good question. I think we're talking by population. I would hope so.
Okay.
Yeah, I'm looking. The ACCG is I'm getting the collective nod from the ACCG where the language came from.
I think we need to clarify that because
that's a great point.
In my circuit that might be an issue. I'm not sure. The other thing that I've got a concern with is on lines 191 to 192 on page 6. The director, basically, as I understand the structure that's being proposed, is that the local advisory panel is going to be going to consist of 3 persons now appointed. One appointed by the Superior Court judge, Chief Superior Court judge, one appointed by the governor, and one appointed by the chairperson of the county commission or chairpersons in a multi-county circuit. Okay, then that group, that panel, is going to come up with 3 nominees as a replacement circuit public defender. My concern is that when you start getting into local politics, I really have a problem with limiting the director's selections to just those 3 nominees. I would ask the chairman and committee to consider the possibility of changing the word shall on line 191 to may, and allow the director some leeway in the event that the 3 persons that are nominated are simply just not qualified.
It's an interesting question, and that actually came up in some of the amendments that I got from ACC, suggested amendments from ACCG. What I heard really from judges and county folks in the local area is that, as a practical matter, they thought that they would have, and let me just back up a second, what that really should say is that the Circuit Public Defender Supervisory Panel shall nominate up to 3 people. And the reason why it's actually meant to say up to 3 people, and that was going to be a technical amendment, not more than 3 people, was that, as a practical matter, they communicated to me that in some cases they would have a tough time coming up with 3, let alone more than that. So I mean,
and I think every circuit's going to be different.
You look at the JNC process. I mean, sometimes in some of the outlying, jurisdictions. I mean, as you know, sometimes even on a judgeship, it's tough to come up with a short list of more than. Sometimes I've seen 2 people, and that's for a judgeship.
Right, and I acknowledge that, but I also feel like that's going to vary from circuit to circuit, and it's going to vary with the personalities involved. And I just want to make sure that the person who is ultimately chosen as a circuit public defender is going to be someone who is actually qualified to serve in that position and doesn't just happen to be a local crony of somebody who makes it onto the panel.
It's absolutely a valid concern, and frankly, I agree. I think the motivation here is that's why we have 3 names as opposed to 1 name, so that what it accomplishes, what it proposes to accomplish, and it's a valid concern, is that you have local buy-in. You have, these are 3 people who, the local people who I think are extremely important to that process, have reviewed. These are 3 people that everyone feels, number one, is competent, qualified, can do the job, and can work well with others. I mean, that's generally what we're looking at. But not, by virtue of having the 3 names as opposed to just 1 name, I think you very much mitigate the possibility of that type of cronyism, because ultimately the director is making that decision. Are they still 3 people who are locally acceptable, for lack of a better term? Sure they are, but I think that's part of the motivation. I think that's a good thing, as opposed to saying, well, this is our guy, and you must have that guy. That's why we vest that power back to the director.
Well, may I, in the alternatives, offer the suggestion that, and I would defer to your feelings on this, Mr. Chairman, but if you would not be in favor of changing the shall to may, then would you consider a provision where the director could reject all three and ask for additional nominations from the panel?
I think that's something to seriously consider. And again, this bill is what I call a system bill. This is for the betterment of the system, and whatever's going to make the system stronger, I'm for. And I don't care where the idea comes from. So,
Thank you.
if it's going to make the system stronger, that's all I care about. But let's think about that. Ms. Benfield.
Thank you. I have 3 questions about the bill, but first I just have an overall question about procedure today. Is this a hearing, or are we voting on the bill today?
I have no preconceived notions about it. I really, as I said, to the vice chair, it's a system bill, and I want it to be as strong as it can be. Obviously, with any measure such as that, I really want it to be as consensus based as we can get it. It will not be perfect to any interested party, but I think it gets almost there for just about everyone who's involved. I really would like to, frankly, take the pulse of the committee. If people, after we have heard from members here and from interested parties, I think it really comes down to the pleasure of the committee. I'd like to get it out the door as expeditiously as possible, but I also want the best bill possible. So.
Okay.
If that answers or doesn't answer your
it's
question.
I have 3 concerns. The first is page 2, section 2, subsection A, starting on line 31, which deals with the qualifications for the director. And this, I recognize this is existing law, and this is a concern that's been raised in the past on this issue. As you probably are aware, the qualifications to be on the board are that, I'm looking at existing law 17-12-3, to be on the board, the members have to have significant experience working in the criminal justice system.
Just tell us again what line you're at.
Oh, I'm looking at existing law. It's not.
I'm sorry.
Yeah,
Okay.
what I'm quoting right now is just, and I can pass it along, but it's qualifications to serve on the board itself. The individual should have significant experience working in the criminal justice system, or demonstrate a strong commitment to adequate and effective representation of indigent defendants. And there is no similar requirement for the director. I know that's been an issue in the past. I'm not pointing fingers at any particular director, because I think we've had good directors, but there have been concerns that there are directors who don't have significant criminal justice experience. Was that something you considered? Is that something you might be open to including as far as qualifications? I think it would make the governance better, because you've got board members who've shown a real involvement at a substantive level in criminal justice issues. To have a director who doesn't have a background at all in that area can create some tension.
I think it's a good question. I'm hesitant to go ahead and make the change in the context of this bill, because, obviously we haven't focused on that in the ongoing meetings and conversations, the working group on this thing. That being said, that's a good piece of evidence as to why we have the statutorily mandated collaborative process between the council and the governor in terms of the hire on the director. That's something that I would think both the executive and the council would focus on in the future. We have our previous immediate past director really did not have a huge background in criminal matters, former member of this body, but I will tell you from conversations with him that he is one of the most thoughtful people on the issue that I've dealt with. We have a new director now who has plenty of experience in criminal law, and I haven't had the opportunity to work with him like I did from Representative Tilley, obviously, and and Rob and I shared a city in terms of our representation here. We do have that experience now, I believe, and I think the new director deserves the benefit of the doubt on his performance, and that applies to us, it applies to the executive, and the governor, and it applies to the council. But the previous director, frankly, Mr. Tilley, was, I thought, very capable and very passionate, and I drew on his limited experience in that role as a resource, and it was a very valuable resource to me in having this make sense. So, I'm not sitting here opposing that. I'd be hesitant on this bill, but I don't think think it's an invalid concern.
Okay.
For sure.
And again, I'm looking at the overall governance issues
Sure.
and not specific personalities or specific directors. I don't even know who the new director is or what his or her experience is, so I'm definitely not pointing fingers. I'm sure my ignorance on that one, he's probably in the room, my apologies. But I do think the language in current law for the members is broad enough. It doesn't say you have to have 6 years working as a prosecutor or public defender or anything of that nature. It just says a significant commitment to these issues that it could apply to a lot of people. So perhaps this is something we could keep in mind.
Sure.
We seem to have this issue pretty much every session.
Which is exactly why we're having this
You don't
bill,
want
so
it
that we
again?
don't have it again.
Well, we will be coming back with funding issues, I hope. I mean, that's
We will.
critical.
We will.
That's been obviously a real
Only
concern.
if you pass this bill out.
Okay. Okay, my second concern is...
Just the messenger.
My second concern is same page, page 2, subsection 2, line 43, where for approval is being removed from existing law. And you stated in your presentation how a lot of what you're trying to achieve here is increasing cooperation between the director and the council. And I think this is an important component of the cooperation to allow the council to have some feedback on changes to their policies, and it's a way of ensuring good governance. And so I'd like to hear why that
Sure.
language was stricken.
I mean, you've hit on one of the cornerstones of the bill, and honestly, it goes back to what I said before about who's in charge. What we have right now are two entities that think they're, institutionally that think they're in charge, and statutorily probably are. You've got the council and then the director, which is an extension of the administration. And that, I think we saw in the previous administration, is not healthy for the system. Ultimately, somebody has to make decisions and implement those decisions, be responsible for those decisions, and be accountable for those decisions. Right now, what we have is a model that doesn't focus that on one entity, whether it's the council or the director. I think my sense is, and I have a feeling that it's got pretty broad support, is that we have to vest that authority in someone. And that someone, just from common sense standpoint, is the director. And we have a council, which I don't think could be, or is relegated to any sort of advisory, status only at all. I think they're very relevant to the operations, to the rules, the policies, the procedures, all of which are maintained in the bill. But we still have to have a situation where we have to have someone in charge. And if we have a situation like we have now, where the possibility of it, at least on paper, where you have the council saying one thing and the director saying another, guess what happens? Nothing. Nothing happens. And that's not good for the system in terms of service delivery.
Has that occurred? Have there been policy changes recommended by the director that the council has rejected and it's resulted in conflict?
I don't sit on the council, and I haven't been the director. I know what I've read in the newspapers, and I think some of the volume and some of the, I wouldn't call animus, but certainly conflict that's occurred arises for two things. Number one, because some people, very few, but it's always the very few that get the most attention and the most volume, sometimes aren't willing to be collaborative. And the other is the statutory structure, and that's our fault.
Last question, if I may ask one final question,
Sure.
and that has to do with, let me find the page. Page 5, line 160. And I know you discussed this when you presented the bill, but you're deleting at least semi-annually and replacing that with annually for these panels to meet. My concern with that, and I know you're aware of the litigation, you talked about it earlier, I think that shows the need for consistent review of how indigent defense is being provided in every circuit. And as we all know, a particular problem that has arisen is the conflict cases, that these conflict cases are not getting representation in a timely fashion. These people are sitting in jails. It's costing us money. And my concern is if you do away with the semi-annual review, that you increase the chance that some of these indigent defendants may be sitting in jail without representation without people reviewing that process.
Well, remember, I mean, the supervisory panel, and the short answer to your question is, if it's the will of the committee to move those required meetings from semi-annual to annually, I'm certainly not going to step up and oppose that. More communication, more collaboration is better than less. I think the motivation on that particular provision was simply for efficiency's sake more than anything else. I don't agree with the lady that it would, that really has a direct relationship between whether or not the system is working or not. But it couldn't hurt. So it could only help. I don't think it could hurt, and if there's a strong feeling on the committee about that, I'm certainly not going to oppose it.
Thank you.
Yes, ma'am. Ms. Byrd, we'll just come around the horn. Oh, I'm sorry, Mr. Ramsey.
Thank you, Mr. Chairman. I do have a quick question, but I do want to. I'd be remiss if I didn't say thank you for the yeoman's effort you've put into this issue. It's just it's an issue that's has needed addressing for a very long time. As many of you know, my background is in corporate law, and the way the statute is set up right now, if I set a company up that way, it is an absolute recipe for gridlock, and I'd probably be sued for malpractice.
You probably have a Sarbanes-Oxley problem
somewhere
in there,
among many others. Right. And I appreciate you taking this on. On line 75 and 78, we have a process for the council members to remove the chairperson, and we create a different standard, a majority versus a supermajority, to remove somebody for cause and to remove somebody without cause. And I don't have the code book in front of me, but is there are we defining for cause, or is there a definition in the existing code that I'm mentioning that I'm missing?
I have to defer to counsel on that. I don't know.
Well, my suggestion would be either we have just a uniform number to remove the chairperson and don't get into the notion of cause versus without cause, or we define what cause is. That's very standard when you set up a corporation, sure. LLC. And this is not an unusual concept, but if we're going to introduce it in here and have a differing standard, a bare majority versus a supermajority with cause, without cause, I think it would be in our interest to either define what cause is or just have one set number to remove a chairperson.
I appreciate the gentleman's comment before. First, thank you. And on that issue, we're going to hear from Mike Berg, who's the chair of the council right now. I'd like to get his thoughts, and as well as perhaps the thoughts of the ACCG on that, but mostly Mr. Berg, as the current chair. And I know he has a vision for effectiveness as well. And for those who don't know, he's also the chair of the Dawson County Commission. So all he does every day is management between the council and the county commission. This man manages 24/7. So I'd like to get his perspective on that. I think that falls under the same analysis of Ms. Benfield's question, which is let's get to the best operative implementing language that we can. Pardon me. Are you good? Okay. Mr. Sessler.
Thank you, Mr. Chairman. Wanted to raise two issues if I could. First one is on page 5, right in the middle of the page, and it deals with the issue of removal of a circuit defender. As the bill is currently drafted, there doesn't appear to be any way to remove a circuit defender at will. It seems to be crafted that there must be a demonstration of removal for cause.
That's correct.
Under our current system, it's granted it's the I'm sorry, was that discussed while I was out, Mr. Chairman?
It was, but I mean we can talk about it again.
I apologize.
I mean that's right.
Okay. Then I'll not knowing what was said, I'll try to make it brief. My concern is I would have an interest in making it apply where the director could remove, not requiring cause, but because again, a 2/3 vote of the council to override that is really consistent with the current framework, where a removal at will requires 2/3 vote of the council. So the protections for the circuit defenders are similar, but I don't know that you really have management and control unless there's the ability to remove at will. And I don't know what the threshold of removal for cause really means.
Well, I mean, and that gets into the whole at will, you know, let me tell you what the motivation was. The motivation was discussed earlier had to do with, you know, we have good people serving in the CPD positions, you know, statewide. I can't tell you exactly how many there are, but I know that the vast majority of them are doing a good job under very difficult circumstances. I would be very concerned about the possibility of having, you know, and this is one of those situations where you have to look at a worst-case scenario about having one of those good people who's been there for X number of years doing a good job, and we get a director in there who for some reason just has some sort of personality conflict or, you know, whatever, some non-substantive issue that arises and comes in and just fires them. I would submit to you that I don't think that's good for the system. Continuity and seamlessness when it comes to this type of operation and institutional knowledge and experience is so important to make sure that the wheels turn and the train runs on time. But if there is a problem, and if there's if a CPD has a personal issue, which is getting into their ability to execute the responsibilities of their office competently, that's, you know, that person, that needs to be addressed, and the director needs to have the ability to do that. We're trying to strike a balance, or if, for instance, if there's a CPD who's just refusing to take, you know, cross-circuit, you know, conflict cases pursuant to the statute, they're just refusing, and the director can't do anything about it. Well, it seems to me the director's got to be able to do something about that. But we don't want to have a situation where the director may come in there, you know, we don't know, the director's a good man, the director before him was a good man. I don't know who the next director is going to be, or who it's going to be, more importantly, 20 years from now. But the CPDs need to have, I believe, some modicum of protection against that type of willy-nilly, you know, potentially abusive termination situation. Because if we had that, it will threaten the integrity of the effectiveness of the system locally, and that'll have I mean, we won't see the effect here. That they'll see the effect locally. It'll turn the whole office on its ear.
I suppose, I guess, if from the perspective of public employment versus private employment, I'm not sure I understand what the threshold that would need to be demonstrated for termination for cause. I mean, this really becomes a conversation of what's required for that. I think I've got a pretty strong feel in the private marketplace what that is. I'm not sure I understand what that is in a public context. And, you know, when you bring in termination for cause for public employees, it is going to be a higher threshold. Do you have to have some underlying direct? I mean, I could speculate what that means. I won't do that with the committee here. I'm just concerned that that's setting a bar up pretty high, and that does a director really? Is the director really empowered to do his or her job if the bar for removal is so high, and there's no provision even for the board to make a removal at will. I don't mean to use that term loosely.
Sure.
But I'm just concerned that without having defined what that bar is that we're in essence creating a confederation of these public defenders. There's not going to be a real central management control. It's going to be more of circuit defenders are empowered on their own to go do their thing.
No, I mean, and this again, it goes to the hire and fire. I mean, in terms of, you know, they have to be able to do their job, and they're doing a good job. In terms of, you know, who's in charge, this bill certainly confers upon the director, in my opinion, the ability to implement policies for the good of the entire system, which would include telling CPD, you know, X, we need you to go ahead and to, you know, take this conflict case across circuit lines and so forth. Well, we can't have a CPD just refusing to do that, and that's, you know, that type of, I would call probably insubordination. Again, if there's a personal conduct issue, for instance, you know, and we've had a few of those in our court system over the past few years, would arise something like that. That goes to the issue that council addressed before about, you know, the for cause, and I may need you to repeat what you said before about, you know, definition of cause and so forth.
There was a standard that was proposed by, it used to be that there were standards that the council adopted, and then it went to the Legislative Oversight Committee, and then eventually went to you all, et cetera. That whole layers has gone away, but there was a standard proposed for removing the public defenders for cause, and I believe that has been adopted. I do not know the status of it exactly at this point now. I'm sure somebody on the council could speak to that, but there is an actual standard that spells out what, or there was.
Within the rules adopted by the council.
Correct.
Yeah. Chairman Berg is nodding his head, and I'll take that as a yes. So,
because again,
does that clarify for you?
Well, Mr. Chairman, I guess it comes back to this whole thing operates and hinges on the definition of what is for cause and what's not for cause.
Right, as it's adopted currently by the council. Okay.
And
maybe we can get a list of what that is. Okay.
Can we discuss that? Is that going to be made available to us today, Mr. Chairman, or is that?
You know, I guess we could get it. Okay. We may take, you know, maybe we'll, after we have a couple witnesses, we may take 5 and go get that just so members can see that and be comforted or discomforted by it.
And by no means, Mr. Chairman, am I trying to be fast and loose with this. I just, the for cause thing, now that there's no provision other than cause, this whole thing hinges on the cause definition. I'm a little concerned that we not box in the director and even the council by having somebody that's sort of a threshold case of
I think the gentleman's concern is well-founded. I would take notice of the fact, though, that we've had these rules as adopted by the council for a number of years now, and it seems, you know, to have worked. What hasn't worked is the ability to actually exercise them in terms of the ability to address them directly, you know, by the director, which is what the bill seeks to do. That said, we may take 5 in a little while, get those, pass them out just so folks can take a look at them.
One more question, Mr. Chairman?
Sure.
Good. My other question, and this is just a question of my knowledge, for capital cases, the capital defender, how does the management and control and execution of the defense process for capital cases fit into this framework? That's just an issue of knowledge for me.
That. Yeah, lines 63 and 64. That's a current duty, responsibility of the director.
So the execution of capital cases, or perhaps I shouldn't use the term execution. The capital defender. Is the hiring and firing control different for the capital defender? How is it different for the capital defender than it would be for example, a circuit public defender?
I mean, you know, pursuant to the current statute, it would vest the ability to hire the capital defender with the director, as you know, as you can see in lines 63 and 64.
So the director does have more discretion for the capital defender than they would for circuit defenders?
I don't know that I would put it at more than the circuit defenders. It would be, well, I guess, frankly, given the fact that the CPD would come from the local supervisory panel recommendation list of 3, then they'd hire from that, and then the director would hire from that list of 3, or whatever we decide to do. There's more of a direct hire, I guess I would call it, as it relates to the capital defender.
Thank you, Mr. Chairman.
Okay. Mr. Coomer.
Thank you. Thank you, Mr. Chairman. First of all, let me say right up front, I want to commend our local circuit defender's office. They have a stable of skillful attorneys in line. Thank you, Mr. Chairman. Let me say that again. I want to first say I want to commend our local circuit defender's office. They have a stable of skillful attorneys. They're really good lawyers, and they're true experts in their craft. And they have earned the respect of the judges, the bar, and the prosecutors in our community. And I'm not not just saying that because our local circuit defender, Mr. Chris Paul, is here in the room this morning. And thank you, Mr. Paul, for being here and for doing such a great job for the Cherokee Circuit. But I want to be clear that what we're talking about in these changes are not a negative reflection of circuit defenders and the job they've done by and large. That said, there have been real problems with management and oversight, and they have a very negative effect on the program overall. I'll give you a couple examples. I recently spoke to a private practice attorney in my community who was appointed as a conflict attorney several years ago. Finished the case. It was a simple case. It was a guilty plea. And he filed his payment voucher with the Public Defender Standards Council in 2008, and he still hasn't been paid. Another conflict lawyer related to me that he had a similar experience, and when he finally spoke to the person in charge of authorizing payment at the council, he was treated to a thorough and sifting cross-examination of his own, and to the point that he asked that person for the contact information for the director to make a complaint. And the person essentially told him, good luck on getting anything done over there, because and the indication was that the director was not considered to be a person with the authority to make any change. And I say that because I think those experiences may help inform the problem that Representative Benefield raised, which is local attorneys not taking conflict cases, having conflict defendants sitting in a jail without a lawyer because you can't get an attorney who's willing to take on the case. And a stronger director, I think, could help alleviate those problems. It's unacceptable to have a program with a director who has to answer for his activities, but who doesn't have any meaningful authority to implement corrective action. I think that's just wrong to do to that director and to that program. And because of that, I come out in support of this bill as it's drafted, with the changes suggested by Vice Chairman Hatfield regarding the clarification of the population issue, and also dealing with the recommendation of Representative Ramsey and Setzler that we clarify the removal for cause issue. I just wanted to clarify my position for the chairman and for members of the audience.
Thank you. I think what we may want to consider doing, Mr. Ramsey, Mr. Setzler, is when we go ahead and take a look at the rules that the council's adopted with regard to what for cause means, we may want to just go ahead and incorporate that by reference, into the statute, for cause as defined by rules as adopted by the council. That may be the, provided the committee is comfortable with that, that may just be the cleanest way to go on that. Ms. Abrams.
Thank you, Mr. Chairman. And some of these questions may be better reserved for Mr. Burke because a couple of them are process, so I'll leave that to your discretion. And part of that would go to line 43, returning to the question of for approval. The process issue I would have would sort of flow from what you've just said about the standards and procedures. I agree that it is important to vest the director with as much power as possible, but I would wonder if it may be splitting a hair to just say for approval, which should not be unreasonably withheld. Because my concern is if certainly we're going to vest them with the ability to adopt the standards for what constitutes for cause, having an outside third party that has at least the ability to comment on these may make, I think, create a more transparent and accountable process for the director. My second question would be with regards to line 67, where we strike in its entirety the requirement that they perform other duties as the council may assign. And again, my question is whether or not this may be better perfected by saying may reasonably assigned necessary to accomplish the purposes of the statute. Because my concern would be that if this is not an exhaustive list, the council may have some request of the director that cannot be met because we completely remove the ability of the council to request the director to take any actions that aren't enumerated in this list.
Here's the fear. The fear that I understand what and I've had this conversation, especially with regard to line 13. In previous drafts, I took a look at that as well, and the note that I wrote to myself was that it gets us right back to where we are, and that it sets up the possibility, depending on who we're talking about, of the inherent conflict of we want you to do this, no, I think I should do that. And if there's an opening statutorily for that to occur, then we're right back at the inertia we have now. I hear you loud and clear, Ms. Abrams. I get it, and if there's a way to do that and still have the director be able to go ahead and do his or her job, both now and 20 years from now. We don't know who that'll be. If Mr. Sackerson is lucky, he'll be doing something else. You know, I just don't want to set up the possibility, because we've seen so many examples, as you know, over the past several years about this internal roiling between personalities and roles and responsibilities, and just conflict, resulting in inertia and nothing. That's my fear. I think it's a legitimate fear based on what we've both read about. So.
And I don't disagree. I guess my concern would be that we're moving from sort of one just completely open-ended, chaotic experience to something that's so absolutist as to not anticipate some process issues that may exist. And I think that's why I'd like to hear Mr. Berg's reaction to this, because I wonder, to the extent that there might be things we're not anticipating, that may be even simple issues that we've now constrained the council from accomplishing. I have one other.
I agree with that. I agree with that, and I think Mr. Berg's perspective on that will be invaluable.
The other place where I appreciate his counsel, and this comes from my experience working with cities and counties, under Section 7, I agree with clarifying how this happens, especially these caucuses, but there's no timetable on this action, and certainly having served as counsel to city council members who will take years to appoint membership, my concern is that if this could be stymied by having one person or at least one body not making their appointment in a timely fashion. So I wonder if it may make sense to, in this section, as we think about clarifying, to include language that sets a timetable on when these appointments have to be made.
Show me exactly where you're talking, just to.
So if you're looking at lines 117 through 122, and actually just the entirety of subsection A on Section 7, page 4, we set up the requirement that we now have these 3 members who are appointed. There's nothing in the body of the statute that requires appointment within a certain time period. So you could have the governor and the Supreme Court. You could have 2 of the appointments made, but under the language that requires a caucus to appoint, if you can't convince the caucus to convene, you never get to the appointment. So if you have a county commissioner and in a multi-county jurisdiction, if those chairpersons refuse to ever convene, you run the risk of never having that appointment made. And so I would simply recommend that we discuss whether there needs to be a timetable for these appointments being made. So within a certain time of a vacancy occurring, they have to convene to take care of filling that vacancy, because currently there's nothing.
And that if you have 2 entities making the appointments that fulfill their appointments and the third one hasn't, you don't want to stymie the. You may have already said this. You don't want to stymie the ability of the first 2 to caucus, since that it does constitute a majority. I'm gonna make it easy on both of us and ask the ACCG, who have very kindly provided some helpful technical amendments, if they could maybe think about that, since that'll actually probably affect them most, I would think, from a practical standpoint. Thank you.
That's it. Thank you.
Mr. Franklin.
Thank you. Hearing some of the discussion about the removal for cause and whatnot, looking at Section 3, it seems like we're getting hung up on the simple majority required for some things and the supermajority of 2/3 for others. But I know I learned my math in the government schools of Alabama, but I believe a simple majority and a 2/3 majority are one and the same when there are only 3 members. So I think we might be.
We're talking about the council itself, where there are 15 members of the council.
Oh, that's the 15-member council? Right. Okay, thank you.
Okay.
Thank you for that clarification.
Thank you. Chairman Berg, this be a good time? Thank you. Mike Berg, for those who don't know, is the chairman of the Dawson County Board of Commissioners, and is also the chairman of the Public Defender Standards Council. And we appreciate his service and appreciate your being here today. And the floor is yours if you want to address any particular points, or if you want to talk generally, or however you want to handle it is certainly fine. And again, thank you for being here.
I also am the 3rd Vice President of the Association of County Commissioners, and so I have that responsibility too.
Let me ask you to talk in the mic.
Sure. It's been an interesting journey over the last 3 years, to say the least. I'm one of 4, I think, on the council that is not a lawyer, and so for me, it started out as more of a passion, but grew into some technical aspects as it went along. I want to say, first of all, Representative Golick has done a yeoman's job in not only trying to put this together, but just in meeting with the varied number of groups that have an interest here. When I first got here and took a look at it, I thought maybe there were 3 or 4 groups, and there are 8 and 9 and 10 different groups that have opinions about the agency. And so to try to put all that in some context and work through it, and so I appreciate that very much, and thank you for that. I think the 2 most important points, as I see it from the agency standpoint, is that there be relevance to the council. That is, the council has something that they do that enables them to represent citizens or those that appoint them, and then secondly, that you have a good management stream. No disrespect to what has gone on before, but I classify our management process as spaghetti management. It's bicameral. Council can make decisions. The director can make decisions. We almost at any point have to go to the AG to determine who's right about the decisions. And so we've had that, and making the agency a management process will so very much help. Will even help financially. Although we do have financial problems, I'm not going to talk about those. I couldn't agree more. You have to straighten out the management first before you can get to the money aspects. And some of the management changes will enable us, I think, to better operate as both the director and the council. And so with that in mind, if you do nothing more than get this management process in order, I think you will have done a great service to everybody. There were a couple of things that were asked. One was this for cause. We've got a situation right now in which we've been working on it for almost 4 months now with a CPD and where there's an issue. And at this point we have for cause, which has to go through a process, and then we have without cause, in which we don't have to go through a process. And the council almost uniformly has chosen to go with the for cause piece of it to give due process to the individual. And so even if there was a without cause, I'm not so sure that the council would use that. Certainly from the CPD aspect, though, I think it's important because they're a different entity than just about everybody else that is involved in the government aspect. Everybody else is elected but them. And so they have some of the same responsibilities as everybody else, but they're not elected by the citizenry. So who do they report to? Under the current management scheme, it really is confusing, and it has caused a lot of questions to be asked. I will tell you that the current director and the majority of the current council are of the same mind in trying to work through the issues. And whenever it's come to a point of which the council looks at something differently than the director has had the upper hand, has had the ability to do what he needs to do. And not so much in Travis or Rob's case, but in Matt Crawford's case when he was working with the council. So there is a list of, I think there's 6 or 7 items for cause, and they'll give that to you, and you'll see that. Whether you want to incorporate that into the bill or not, that's up to y'all, but it is there. And certainly we'll use that as we go through this one aspect of one of the CPDs in one of the areas and the issues that we have. Overall, this is very important for the council and the director to define where they are, and if you can't do anything else but that, so that we have some clear lines of where we're going, it's going to help everybody. And again, I appreciate you doing what you've done, and we're certainly all willing to work on whatever it is that brings us to conclusion. And with that, I'll answer questions.
Thank you, Mr. Chairman. I wanted to thank you personally for your help and guidance. I know what I know, and I know what I don't know, and I did well, I think, hopefully, over the last year, just listening, asking a bunch of dumb questions, which I continue to do, as you can tell. But I think that's good because it gets us to where we need to be. Mr. Setzler.
Thank you, Mr. Chairman. And Mr. Berg, good to see you again.
Yes, sir.
Appreciate you being here. And we're all trying to drive towards the same goal and objective. I mean, I know that. I guess though, as I try to unpack this, and I don't want to spend too much time. I don't want to waste the chairman's or the committee's time. But I guess I don't know anywhere else, and maybe you can help me with this. I don't know anywhere else in government where you've got a standard, other than folks that have a specified term of office, so to speak, where there's a standard of cause for removal. I mean, I think, as I anticipate this would be executed in practice, there would need to be some demonstration of cause for someone to be removed, certainly, and have that removal approved by the board on appeal. Now, I think if there becomes a personality conflict, you've got a 15-member board. These are very capable, experienced professionals in their own right. They're not going to just kind of wilt at the suggestion of the director. I just don't understand why we feel like we need to put in a for cause requirement here when I'm not sure, when you look at local government, I'm not sure that any of the appointments that are made for key staffers in local government have a for cause clause in their contract, or that anyone in the executive branch the governor appoints has a for clause in their contract. I'm just trying to understand why we need to set that, hard code that in the statute rather than just have that as a management best practice.
Yeah. And I would tell you that in a pure management sense, you hire somebody, they work for you, and if you like what they're doing, that's fine. If you don't, then you let them go and find somebody else, and that's a direct stream of management. And but it's gotten more complicated than that, because you do have CPDs who do not fit into the category of just about any other relationship in county and in state government, and for them, they've invested so much time and talent into what they do. It is good to have a listing, if nothing else, for them to go by that says, here are the things that you're supposed to do. If you don't do those things, then you're subject to be removed. Now we have the issue where the director does not have full responsibility to remove. And so just getting to that step would be most helpful. But again, if you want to put those particular things into the bill to set them up, fine. Even if you didn't, as I've just mentioned in the case we've got, we haven't used the for cause piece, without cause piece. We want to hear what has transpired and then try to make a decision and fit that into the for cause process.
What's the term of these circuit defenders? Is there an anticipated term of service when they're appointed?
Yeah, I really don't know that. Is it 4 years? Yeah. Okay. Yeah.
Is it again? This is just a question for the assembly here. Do they have to be reappointed after that 4-year term? So they have to go through the full approval process here?
Well, under the panel system, and let me talk just a second about the panel system, because that's one of the crazier parts of what we've been through. There are no less than 305 appointments in these panels, and some of them have gone lacking for a period of a year and a half, 2 years. Some of them have been reappointed. That just does not work. And so going to 3 and having it by position rather than person is just an excellent way to go about it. I would assume that the panel would get together and make the recommendation that they be reappointed, and the process now is that they would be reappointed through that panel. If this changes, then I would assume that the director would have a responsibility in that regard.
One more question, Mr. Chairman, if I could. As a practical matter, folks that are appointed as circuit public defenders, are they leaving practices where the decision to become a circuit defender, you've got to close down clients, you have to make sort of a step of faith professionally to take on a job, perhaps lower compensation, that kind of thing?
Yeah, those circuit defenders that are here would be far better equipped to answer that than I would. I'm sure there's a varied number of reasons.
And I raise that question because to the extent folks are making a fragile career move, where if they were working, where they could potentially capriciously be fired by a boss they don't get along with, perhaps they've left behind a law practice that they've. So to the extent that's the case, maybe it's persuasive that you have this standard for removal. So I just offer that to the committee.
Mr. Vice Chair.
I was just going to speak to that question. I think that you're going to find that some of these public defenders have been private practitioners may be leaving private practice, closing down their practice and giving up clients and basically making a substantial investment of time and effort and their professional goodwill into this new job. And so they are going to be people who are looking for some job security in making that investment on behalf of the people of the state.
Ms. Abrams.
Thank you. Mr. Berg, if I can direct your attention, do you have the legislation?
I do.
First to line 43, which I think Representative Benfield and I both raised concerns about. Can you speak to whether or not, as a council member, the removal of any approval process, it's on page 2, line 43?
43?
Yes, line 43.
All right, sorry.
It's okay. Can you speak to the concerns that we've had about removing approval at all? Just seems to be sort of an absolutist policy that may create some concerns about the nature of the rules, policies, procedures, and regulations that are developed. Can you speak to your thoughts
Sure.
on that?
Overall, when I first saw this, I was concerned about the approval being marked out because you do want relevance on the council. And if you don't, just by very nature of not having that, you will have an advisory group that you'll have a hard time getting folks to serve on. There wouldn't be the passion there because they wouldn't have any responsibility to the agency. If you look at line 44 through 47, it kind of comes back around to giving at least some of those responsibilities to the council. I don't know whether that was the intent as it went through, but there may be some incongruency there between 43 and 44 through 47.
Right.
That, as a technicality you may have to work out. Certainly, again, you want the council to be able to have relevance.
And the same question would go to line 67 on page 3. And my concern here is one where, just from a sort of nonprofit management standpoint, or any organization where you have a board that can provide, that has a director, this basically precludes the board from requiring any other activities other than those strictly enumerated in the code. Do you have any concerns about that removal?
Well, in a pure sense, at least from a county government aspect, what we try to do is separate policy from management. Boards of commissioners make policy decisions. Administrators, county managers, whomever make day-to-day decisions. And so there's a clear distinction there, and hopefully what this will get to is a clear distinction here so that the manager, the director in this case, can do what he has to do to make the agency all that it can be. I've not seen in the last year and a half that I've been chair where the council has put on extra responsibility to the director. But certainly there are times when the council would ask the director to look into something or to promote something that would help the agency. I would hope that the director would do that without having to say in law, you've got to have these other responsibilities, because the other side of that is if you have some council members that decide that they want something that's obscure and for some reason the board goes along with them, then all of a sudden the director is doing something that really takes away from the agency. So it's a give and take. If you put it in, then you're hung with it no matter who's there. If you leave it out, then hopefully good working relationship will allow you to get that done anyway if you need to.
Thank you. Mr. Chairman, if I may ask one final question. Going back to the, Mr. Berg, going back to lines 41 through 45, to your point about removing that requirement, do you read these two sections to be in conflict? If we were, I guess where I am is that I would be satisfied if it is such that the council can adopt certain policies that the director is then required to administer. But where do you see, just sort of a speculative exercise, if the policies that are adopted by the council conflict with the policies that are adopted and developed by the director?
In most of the organizations that I've been in, again, you have this split where the policies are made by the board, and they're carried out by the director. And so I would lean more toward those. Again, I think if you have a good working relationship, those things are going to be done anyway, and you might not have to ever worry about going through something like this. But certainly taking out approval, if you had a very strong director that wanted to go opposite of the views of the council, you'd have an issue because of that, because of what's in here. But I think technically you can work through that with 44 through 47 to make some change that would make that fit. I think that's a small part of it. I think it's important, but I do think you can make it fit.
Thank you.
I do see Ms. Abrams' point about the congruence of 2 and 3. I think, as I have understood it, both then and now, it's more of a, in looking at Section 2 there, lines 41 to 43, I'm looking at it in terms of, carrying out provisions of the law, standards, regulations, and so forth, compliance with the law and doing what is necessary, for such compliance. And I see 44 and 45 as being, and frankly 46 and 47 as well, although that's obvious. But subsection 3 there, lines 44 and 45 is almost being more internal than anything. That's how I've read it. If there's a way for that to be more artfully worded, that's fine. But I wouldn't say that's my motivation, because frankly that's existing law. But that's how I've come to look at it, and then I hear Mr. Berg's, real world on the street perspective, and I think it would be workable.
No, I don't disagree. I guess my concern is sort of, you pass, I think in any organization, the rules are designed for the moments when people can't do what's reasonable. When you want them to look at what they have to do, since they don't want to do what they should do. And so my concern would be that you've created between these two sections, especially if you remove, in my mind, I imagine a council member who has no longer the ability to require the performance of duties, who sits and looks at this and says, okay, well, I can't require the performance of certain duties, but if I look at subsection 3, I can adopt certain policies that require behavior by the director, and that you use that as sort of your hook to get what you want because you couldn't get it any other way.
If I might,
if that were to be abused by the council,
it goes both ways. It could, thinking people you would think would come to the best conclusion. But you're right, as it's written, there could be situations where that would occur, and then having just this to go by, you really don't have much responsibility. But I think it can be worked so that you.
Is the cure then perhaps just out of an abundance of caution to make lines 44 and 45 applicable to the internal operations of the council, and to limit it to that? Just dangerously thinking out loud, but just something to think about. If it can be more artfully worded, because Ms. Abrams is frankly stating the concern that I had before, is that if we're going to adopt a certain model, there's no sense in having it, have the possibility of an end run. That doesn't do the system any good. Ms. Benfield.
Thank you. Most of this discussion has addressed my concerns. I do find removing the for approval potentially a problem. And I did want to ask, from your real life experience, can you recall any specific times when policy, rule, procedure, regulation, et cetera, was submitted and not approved? And I'm assuming approval is by a majority vote, by a simple majority.
It is, and yes, we've had those issues. Some of them, as Representative Golick has said, are because of personalities on the council, which they'll change eventually. But there are situations that the council has had one way of looking at something, the directors had another way of looking at something, and because we've got this bicameral association, we're always in a discussion of who's right, and if this does anything, if it gives us a path to let us know where we both are, I think that will be most helpful. When we've been to the AG's office to discuss the issues, the AG has fallen almost solely on the director's side of that, which I certainly can understand. So there have been situations.
Can I just brief follow-up?
Sure.
Have there been published AG opinions or opinions that you could share with us that might be informative as we're working through the bill?
If you've ever had to deal with the AG's office,
I have.
You almost never get a published opinion. What you get is, here's our thoughts. If you want a published opinion, come back and see us a little bit later, and within the year we'll have something for you. That doesn't solve the issue right then. So we've mostly gotten, here's our opinion. If you want that in writing, call me next year.
And you did not follow up with the writing?
Well, I mean, a year later, the issue is gone, or there's something else to go on with.
Can I ask one more?
Sure.
I do have the other concern I raised earlier dealt with going from the semi-annual reviews to the annual reviews with these panels and the supervisory panels with the circuit public defenders. Can you address a concern I have about the conflict cases? And I used to be a public defender, so I'm aware of how hard it is, and there's so many conflict cases, to make sure that these persons have adequate representation in a timely fashion. So I have for you to speak to the conflict case in particular, that issue.
We're in a unique time in our lives with conflicts because of the opinion by the bar and the opinion that will be coming by the Supreme Court, hopefully to talk about the ethical screens and where we are. It's really difficult for the director and for the council at this point to handle conflicts because you don't have a finite number, and it's a moving target. Right now, the director is doing some cross-circuit conflict cases because there's no other way to do that. It's the least preferable way to do something, but with the limited funds and the issue being up in the air, there's not much else he can do. As soon as we can get an opinion from the Supreme Court, I think that'll give the CPDs and the judges a better feeling of where they are with that issue. It's not going to solve the issue, but I think it'll get it in better perspective where it can be more easily handled.
Thank you.
Just for members, we have a copy of the standards for removal of a circuit public defender for cause pursuant to OCGA 17-12-20. That's been passed out to each individual member for you to have. Chairman Berg, what's your opinion on whether that should be incorporated into the statute or just leave it alone?
Well, if it's not in the statute, then the council could change at any time, and so you've got that issue. It's more flexible with the council. It's less flexible if you put it in statute. But regardless, I think that in each instance, because of the number of council members, I have a very good feeling that they're going to do the right thing. They're not going to let something go on that shouldn't go on. We're stuck with a time frame situation now because of the rules that we've got now, not because of these, but because of what processes we have to go through. You've cleaned up those, and that'll give us a better time frame to do that. I'm ambivalent to whether it's with the council or whether it's in statute.
Okay, Mr. Ramsey.
Just out of curiosity, do you have, as the chairman of the council, do you have any role beyond kind of the ministerial act of setting and running the meetings? You have one vote just as everybody else, but is there anything else that you do as chairman beyond run the meetings?
No.
Okay, thank you.
Mr. Atwood.
I passed, Mr. Chairman. My question's already been answered.
You're a good man. Thank you. No further questions, Chairman Burke. We really
thank you.
Thank you so much for your service and for your patience. I don't know how you do both of the things that you do. I really don't. Thank you very much. Let me ask, is there a representative of the State Bar who... Oh, I'm sorry, Brian Cavan is the former president of the State Bar. Mr. Cavan, please come forward. We'd love to hear your thoughts on what you have to say about the substitute. And just when you thought you were done with your State Bar duties... What's the line from one of the Godfather movies? They pull me back in.
Something along that line. I didn't pull my hand down fast enough or whatever. Let me first of all say, on behalf of the bar.
If you could move the microphone. Thank you very much.
On behalf of the bar, Chairman Golick, we sincerely appreciate your efforts in this and your continued willingness to work with the working group and with us to correct some issues and to bring about some answers to the governance issues, and as we move our way toward funding. We just sincerely appreciate your efforts.
Thank you very much. The bar has been a tremendous asset for me personally and for the committee. I know that's not going to change. It's not something that we take for granted. The bar always advertises itself as being a tremendous resource on issues such as this, and that's the truth. So there's truth in advertising there, and we appreciate it.
Thank you. Thank you on behalf of the bar. I will simply say that with regard to this legislation, the bar is supportive of the legislation. There are some things that you're hearing about. You're hearing about from the members of the committee that we stand ready to, in any way we can help in this dialogue, to work with this, but we certainly support the legislation.
Thank you. Thank you very much. Any questions for Mr. Cavan of the State Bar, representing the State Bar? Seeing none. Thank you, sir.
Thank you.
Did ACCG want to be recognized to make any comments, or no? You're under no duty, Jim. I saw you there behind Brian, so I wanted to. Okay. Thank you. Let me Sandra Michaels on behalf of the Georgia Association of Criminal Defense Lawyers.
Thank you, Mr. Chairman. I appreciate it.
Sure.
Again, I'm Sandra Michaels.
If you could pull the microphone
Yes,
toward
sir.
you. Thank you.
I'm Sandra Michaels for the Georgia Association of Criminal Defense Lawyers, and I appreciate the chairman allowing GACDL representatives to participate in the process. As many of you know, we represent the criminal defense lawyers in the state, which includes not just folks from the private bar, it includes the public defenders and the CPDs, who are valued members of our organization. We have vowed to represent our CPDs and our PDs and to help them or assist them in any way they ask us to do so. And as such, I'm speaking on behalf of GACDL with input from our members. And I may make suggestions that maybe CPDs or PDs are not able to do, but many of the suggestions I made in the memorandum that we've sent via email to each one of you have already been made in the substitute, and we appreciate that. Some of the issues that our circuit public defenders and our public defenders have brought to our attention that request assistance on have been raised today. And specifically, one area that they feel very strongly about, and we support them in, is on page 2, line 43, which has already been discussed, that the words for approval be restored to paragraph 2 in lines 41 for 43. The thought process behind that is that the council should be responsible for policy and the director should carry out that policy. Some of the discussion today indicated why that's important. The council is made up of a variety of different people that come from different experiences, some administrative experience, some criminal defense, some prosecution, some just basic good governing based in their experiences. It's not always clear that the director will have the same experience that the variety and of the council will. So the thought is that the council would have a better background to think of what policy would be appropriate for an indigent defense agency. So that's the thought, that that would be a better way to handle that. The other issue, and I believe it's raised in my memorandum, is on page 3, line 67. Using the same argument that I just stated, there has been requests that we ask that the section 13 be added back into the bill, perform other duties as the council may assign. And again, the thought process on that is that things may come up that is better decided by a council or a group of people, greater minds think together than just one thought. And this at least allows the flexibility for that circumstance to occur. Some of the issues that have been discussed earlier have also been a concern of the Georgia Association of Criminal Defense Lawyers. One is the issue about how is cause defined. You've already addressed that. That was one issue that folks were concerned about. Conflicts are going to be an issue. They're not necessarily addressed in this bill. I will tell you that every email I've received in the last 6 months has been concerns about conflicts. If the CPD serves at the pleasure of the director and the issue comes up that the CPD is not taking a certain conflict case or a certain number of conflict cases, one should assume that the CPD is doing that for honorable reasons. Their concern is that they could be terminated at will, so to speak, if they don't take those conflicts. And again, there's issues such as the caseload is very high. A lot of you are a lot younger than I am, and you may not remember, but there was a time about 15, 20 years ago where our caseload was one of the highest in the nation for our public defenders, which caused a huge breakdown in the system, which resulted in the statewide public defender system. And we are getting perilously high to those number of cases again. So that is one issue that has been raised to me, as I said, repeatedly in the last 6 months by concerns of our CPDs and public defenders. And finally, one unintended consequence in the bill that has been brought to my attention by a number of people, if ultimately the director would have final approval of which of the 3 CPD candidates would get the job and can reject the 3 offers and say, bring me 3 more until that person is, there is an argument that could be made that this is now one big firm instead of, I think as the word was used earlier, a confederation of CPDs around the state. If it is one firm, that weakens the argument under existing case law and ABA guidelines that they can take conflicts and share them throughout the state. And again, that has been brought to me by a number of people saying this is a concern. The thought is, sure, if there's, the thought was, and again, I'm playing both sides here because the issue is conflict. You know, you always have the Chinese wall, federal defenders, you know, and it's been clear that a federal defender office cannot handle conflict. If the public defender system, if right now, if we have a loose confederation of CPDs around the state based on area, their argument has been made that, hey, one office can handle the other's conflicts, and since they don't share staff, computers, resources, we're good. We're complying with ABA guidelines, case law, whatever, what a conflict is. But the argument can be made if this bill goes through as written and it becomes purely all CPDs are really appointed by the pleasure of the director, for all intents and purposes, that a CPD can be replaced or appointed by the director. The logical extension of that argument is you are now really one firm. Everyone works under the director. It's not a loose confederation of CPDs working at the pleasure of the council. So you weaken your argument now that conflicts can legitimately be handled between offices. Again, this is not my idea, but it's brought to me by several different people from different walks of life. It's not one rumor that hit, hey, we need to think about this. It's a thought, and I just toss it out there.
Well, then, based on that, then the suggestion that I had as far as the director being able to reject the 3 nominees submitted by the supervisory panel, you feel like that would even make the director's position stronger and therefore would be more in keeping with what you're arguing here, that somehow makes this a unified firm.
Yes, I think so.
I just don't see it that way. I mean, these are people that are coming from different communities. They're ultimately, either way you do it, whether the way it's written or based on the suggestion that I made, you've still got nominees that are coming from the supervisory panel, which is composed of people in that community. And so I just don't, I understand what you're saying. I just kind of don't agree with that.
I understand that. I mean, I think that, as I said, I came in here, conflict is an issue that GACDL has been approached, is extremely concerned about. And I think our policy is very clear what a conflict is a conflict. I mean, I come from the federal defender system. Mr. Pack knows it's very, if there's any hint of a conflict in a case, it is split. I think Mr. Berg is correct. I think it's ultimately going to be decided by the courts. But I toss that out there as that may be an issue.
Well, I agree that's something we want to make sure we get right, and that conflicts seem to be the major issue of concern right now. But by the same token, I don't think we can guess what the court's response, what any court is going to say about that down the road. I think we have to do the best job we can with the structure, and then if we have court decisions that create a problem, then we'll come back and revisit it. But right now, I just don't see that as being a legitimate way of looking at it, as these various public defenders are somehow one firm. I would just reject that.
Well, I understand, but I think the case law and the ABA guidelines are clear on what conflicts are, and obviously we could debate that for days.
I know.
Mr.
Pack.
Oh, I'm sorry.
Sorry, Mr. Pack.
A quick question as we're reviewing the oversight guidelines here, and tied to your conflicts comment, is it possible, since the removal for cause is limited, or I think the intent was to limit it to specific instances where taking a particular strategy is not one of the grounds to remove the capital defender, would that kind of address some of the concerns maybe your organization might have about having one director having the power to fire these individuals would in fact result in a one firm type of concept?
I have not had a chance to review that list, but assuming that is, that would maybe come into effect.
Okay.
And very briefly, I'm cognizant of the time. On page 6, in the substitute lines, specifically 185 to 192, we would request that it go back to read, if a vacancy occurs for the position of circuit public defender, the director shall appoint an interim circuit public defender to serve until, and restore the language that is already there, and restore the word appoint in line 188. And then where it says the very last line, 191 to 192, the director shall select the replacement. Again, I think, I've already talked about that before. I think it adds to the issue of the conflicts, and certainly our members were concerned about that. But they would like that language restored to appoint, as opposed to just the it being nominated.
Well, what we're doing, and this goes back to the conversation before, and I'll recognize Ms. Enfield, is that we are trying to strike a balance between making sure that we have local, significant, substantive local input by significant individuals locally, so that they know that they're going to have one of three people, according to the current language, who is up to the job, that they no doubt have personal experience with collectively, and they're comfortable with collectively, not just one but three, to get over the possibility of politics permeating it, from the vice chair's comments earlier, which I agree with. But also recognizing the fact that this is someone the director has to work with.
Yes,
and so you're striking that balance between the local buy-in, local feedback. It's going to be one of those three people under this proposal. They can do the job. They've worked with them before as a practical matter. They can do it seamless, attitude, everything. And then you have, of course, the fact that the director, has a good pool of people to deal with, to choose from, and that he or she feels that they can work with. It's a tough balance, but that's the motivation. I think it strikes the proper balance of those not competing interests, but significant, total interests. Ms. Benfield.
Thank you. And a lot of the issues I have already been addressed, but I just want to touch on what I think is the largest concern I'm hearing today and have heard in the past with the current system is the conflict cases. I mean, that's what's causing governance problems, and also the cost issue. And I'm just interested in hearing from you, Ms. Michaels, what you're hearing from the different circuit defenders about what's working right with the conflict cases and what's not working as well. At some point did we have a conflict, like a complete separate conflict defender office?
Yes.
And what happened with that? Okay, and if you could just speak to sort of the models out
Sure.
there, what worked, what didn't work. I'm not trying to go beyond the parameters. I know this is a lot of effort, what's before us, but I do think the conflict cases, that's really the crux of the problem.
Well, and I'm just speaking, of course, based on what we're told, as far as from the state. I mean, the issues are, I think, the overriding issue right now is that the caseloads are huge.
Yeah.
And if members or folks are asked to go to another circuit and take their conflict cases, not only do they have their own caseload in their own community to handle, they now have to drive sometimes a very long distance to another case. And to do the job right, you just don't. You may remember when we first started practicing meet, greet, and plead. You don't do that. That's completely wrong. I mean, you are ineffective. And to do the work right, you will now have to go to another county, another part of the state, which I know the effort's been made to make it contiguous counties, so you don't presumably have to drive more than several hundred miles. But you still have to investigate. You still have to meet with your client. You still have to do that job properly, as well as your own job in your own county. And the time commitment and the resource stretched thin is the main issue we are hearing over and over again, and it's scary. And the flip side is, and there's worry, and I'm speaking freely here, there's worry if that is brought to the attention, there'll be reprisals. And folks are worried about it, because I say this now. I think those of you that know, people that go into criminal defense are not doing it for a job. They care very deeply about it. It is not a job. It's a calling. And if people are not taken as a job just to make money, they really care about what they're doing, want to do a good job. I think the CPDs are clear. They're fabulous people. Public defenders do a lot of work. And if they say no, it's for a good reason. If they say I can't do anymore, it's for a very valid legal or ethical reason. So I think their concerns are that. What used to work, which I don't think, back when there wasn't the issue about money and funding, I think having folks appointed, good folks, known quantities, people that are going to do a good job, a list like they do at the federal defender. They have a list of attorneys.
Private attorneys.
Of private attorneys that will take a job for a reduced hourly rate, and the courts, the prosecutors, and the defense know that they'll do a good job. Admittedly, doing it at a reduced rate. I mean, far less than the average civil attorney makes per hour, or even the private criminal defense attorney. And that system seemed to work well. What happened with that, everybody has an opinion, and I don't know. Does that answer your question?
That's helpful. Thank you.
And the last two things I've been asked to address.
I need you to wind up pretty.
Yes, sir. Page 6, line 201. Please restore the words "the council" for the same policy reasons I mentioned before. And on page 7, line 203, restore the council to making policy decisions and the director carrying out. And that's all I have. Thank you.
Thank you, Ms. Michaels. Let me call our last witness that I have here, Ms. Melanie Velez.
Thank you, Representative Golick. We at the Southern Center appreciate your time on this important issue. My name is Melanie Velez. I'm a managing attorney at the Southern Center for Human Rights, where I've worked for the past 6 years. We're grateful for the leadership that you've taken on this issue, as on others. Representative Golick, Sarah Tatachi, the director of my office, is unable to be here today and asked me to extend regrets on her part. We just have a couple of issues, and I will be brief because I know that you've kept us on schedule today. And
thank you.
I will be sure to address my issues in a timely fashion. We at the Southern Center for Human Rights believe that HB 238 eliminates certain issues, as has already been mentioned numerous times today regarding governance. And so I will just raise a couple of the issues that we are concerned about, each of which has already been raised today. The first is in Section 2, page 2, lines 41 to 53, this goes to the issue of the council being able to approve policies, procedures, regulations, and standards that are prepared and by the director. We think this is an important point for several reasons. I think that our experience on our litigation has demonstrated that if the council had had certain opportunities in the past to review policies and procedures promulgated by the director, that in certain instances litigation could have been avoided, and that's certainly true with regard to the conflicts issue. We brought one case in the Northern Circuit of Georgia a year and a half ago, which we've since settled, that pertained to the conflicts issue. In particular, we filed the case on behalf of a couple of hundred of individuals who were pre-trial, who were not appointed conflict counsel. And the policy that prompted that gap in representation was a product of the director at that time. And I know we're not casting fingers or pointing fingers, but I think it is an important example of what went wrong. And if the council had had more oversight at that stage, I think that issue could have been avoided. And it wasn't simply one of putting enough money where it was needed, but also one of governance. And so we would favor that the language for approval be reinstated at line 43. And I also wanted to address, there was the issue raised by Representative Benefield regarding conflicts. And yes, there was a time when conflict defender offices were positioned throughout the state, and that was for several reasons the best way to handle conflicts, one of which was economies of scale. You had one office who had dedicated employees and investigators, for example. The second issue I wanted to raise was raised by Representative Benefield earlier, and that's the qualifications of the director. There is already language in the statute that sets forth what we view at the Southern Center as very basic requirements and qualifications for the council members as well as most members of the local supervisory panel. And so we would recommend that that language be adopted and applicable to the director himself. And that's simply the language that the director shall be an individual with significant experience working in the criminal justice system, or who has demonstrated a strong commitment to the provision of adequate and effective representation of indigent defendants. My third and final point pertains to section 7, page 5, lines 160 and 166. This is also a point about accountability and governance that was addressed earlier. We believe that instead of having merely annual reviews, that semi-annual reviews conducted by the local supervisory panels are advisable. It's another way to promote accountability in the system by ensuring that the local supervisory panel members are engaged throughout the year and not simply at one point during the year. We recognize the record of the local supervisory panels for various reasons in the past has led to infrequent meetings and not often very active conduct. We believe that the step that Representative Golick has proposed to reducing the number of members will help promote activity, and therefore recommend that the language at line 160 and 166 be restored to allow for semi-annual review. I think it's an important way, whether it's on the issue of conflicts or any other issues that may arise, for there to be constant engagement and review. And I think that the counties and local supervisory panels, through local supervisory panels, can be more engaged on this issue. And the counties in particular have taken great steps to support indigent defense in the state, and that having them meet at least twice a year would be very important. And that's all I have.
Thank you, Ms. Velez, for joining us this morning. I see no questions.
Thank you.
Okay. Let me tell you where we're at. We do have a meeting on Monday morning at 9:30. I said early on we would go ahead and take advantage of recess days, and we're going to. We're getting into that period where we do well to go ahead and take advantage of those days to the extent that we can. That doesn't mean that we won't meet on non-recess days. It's just that we can accomplish more on a recess day, and then maybe fill in on regular work days or regular session days as needed. What I'm going to do is hold this bill pending a fresh substitute being drafted that incorporates some of the changes, some of the suggestions that were discussed today. And I thought it was really good, a good meeting, a good dialogue, and good questions asked from members of both sides. of the aisle. And we'll go ahead and have a fresh substitute ready for consideration on Monday morning. We'll go ahead and kick that meeting off with this bill. We'll finish that up, go to a motion. We'll go to Representative Pack's bill on video depositions after that, and then we'll get into House Bill 200, which is the human trafficking bill that Mr. Lindsay has put forward. There's also going to be, just for members' information, there'll be a committee lunch on Monday, and you'll get a notice about that from staff later this morning or this afternoon. If you can attend, that would be great. I think you'll enjoy it. And there's going to be lunch available for members here today down the hall in room 133. We'll have that. The Setzler subcommittee will still meet at 1 o'clock. So we'll make every effort to expedite matters here, but we'll do that in a timely manner. We'll get our business done in a timely manner so we can convene on time for that subcommittee, or as close to on time as possible. Yeah.
Because the lunch at 11:30, would it be better to have the Setzler subcommittee slip back to 1:30? I don't know about the timing.
If you can do that, that would be ideal.
Okay, we'll do that, Mr. Chairman.
Okay, 1:30 for the Setzler subcommittee on Monday, Mr. Vice Chairman.
Mr. Chairman, I just want to follow up with another question on the bill,
sure,
if I may. Is there, and maybe someone from the council or can help us, or legislative council, but there's not any requirement that I see in the code right now that the circuit public defender actually be a resident or an attorney within that circuit, is there?
Legislation coming up, a lot of the circuit public defenders that have been in an office for a long time did not initially come from that circuit. I live in Newton County, although I work in Rockdale. I'm 2/10 of a mile across the border. So if we said you've got to be from that county, I couldn't do it. Terry Everett, who was the Houston County Public Defender, actually came from Alabama. Drew Powell, the one up in the Mountain Circuit, initially came from Atlanta. Same thing for Donna Segrist. She came from Atlanta initially. So a lot of us, and Clay Culp down in the Waycross Circuit, originally came from Atlanta. A lot of the folks came from other areas, not from that circuit. So that may cut out the number of people who can take those jobs if you say you've got to reside in that circuit.
But like for example, Clay Culp, they moved to Waycross.
Would you mind coming forward and just identifying yourself for the folks? I appreciate it.
My name is Stephen Purvis. I'm the public defender for Rockdale County. I've been there for about 16 years. I initially was in Atlanta. I moved out to Rockdale after I got the job, but I couldn't find a house in Rockdale County. And like I said, I bought a house in Newton County, 2/10 of a mile across the border. But a lot of the circuit public defenders, when they got these jobs, did not come from that circuit. They came from elsewhere.
But you don't currently live within your circuit?
I do not.
Okay.
I'm 2/10 of a mile across the border, and if you said you can't do it unless you live there, I've been there 16 years doing this job, so they would then say I'd have to buy a house in Rockdale County.
Right. Okay. Okay.
I was remiss before. Was there anyone who was not signed up who wanted to be heard on House Bill 238? Seeing that, Ms. Benfield, did you have a question?
Yes, I just want to throw out one thought on page 5, the provision dealing with the semi-annual versus annual review by the supervisory panels, and the concern I had raised earlier with doing away with the semi-annual review is that there be some oversight, specifically with regard to the caseload and the conflict cases. But in further reading of this provision, it doesn't specifically address that the caseload would be considered with the annual or semi-annual review, whenever the review is. And I'm just throwing out for consideration, we might want to consider putting in reviewing caseload, reviewing conflict cases. I don't want to.
I heard what the gentlelady
Just throwing
was saying.
it out there.
I just as I said before, the issue of semi-annual and annual, I believe in erring on the side of caution when it comes to communication and being hands-on as it relates to things you've got oversight on. I have got to think that that's a natural, organic part of that either annual or semi-annual conversation. So, I mean, and I'm hesitant then to go ahead and codify that, because then you're running the risk of people interpreting that as, well, that's in there, but there's something else is not. Does that mean we can't talk about it? I'd rather have that more open-ended than less open-ended in terms of that communication, regardless of how often it is. I have to think that's going to happen organically.
I just
want
a comfort level that specific issue, which is
it's better to ask.
A huge issue here, the conflict cases.
Understood, but that's why but again, going back to the first thing we talked about, is it. I'm not saying everything gets certainly not everything gets solved with money. We've learned that a long time ago in this building, haven't we? But there is a funding aspect to this issue that's undeniable. Will that be an all-encompassing panacea to this issue? No. But will it be helpful? Yes, it will. And I'm committed to getting to that in cooperation with the administration and the legislative leadership of both sides. But we've got to get through this first before we get there. So I hear you. Ms. Abdul Salam.
Thank you, Mr. Chairman. Just a comment. In talking with our circuit public defenders, one of the things that they really did have concern about was the semi-annual. That they preferred to have more than less. Even though they're one of the ones that had trouble getting their councils to meet, they seem to think that reducing it to 3 and still doing the semi-annual would work best. So I just wanted to say that I've heard from Clayton and Fayette, and we'd like to consider that as well.
Thank you. Mr. Sessler.
Thank you, Mr. Chairman. I would just offer to you, in wrapping up, as we discussed earlier, I have reviewed what the councils provided as their standards for removal of a circuit public defender. I'm very comfortable, in terms of the standard they've defined as removal from cause. My concerns, I think, are covered in this. Okay. What I would offer, would you consider maybe adopting some of this into the statute itself to give some certainty there?
I would. I'll consider just about anything that's reasonable. I wonder if I'd like to make things as I believe in keeping it simple wherever we can. If that means, and I would want to discuss this with council as we go ahead and draft the next substitute, hopefully for a motion on Monday, as to whether just simply a corporation by reference of whatever standards are adopted might be the best path to take. But let's have that conversation and let's see how that substitute comes out. But I don't think that can hurt, and I think if anything, by virtue of incorporating these standards by reference into that applicable code section, I would think that would give the CPDs more comfort than less about this due process protection.
And again, Mr. Chairman, my concern is that, I guess my only concern on the reference is that to the extent the council is really the arbiter of that and can set those, it might not give the certainty that I think this committee is looking to give in terms of what the role of the director is, what the role of the council is. So if we were to, again, at least consider hard coding some of this into the statute, as I would call it, I think the only change I would make to what they've provided is in subpart B here, the removal for willful disobedience of the directions of this current language reads council. I would perhaps say director, and that might be the only change. But everything else, as I read it, I'm very comfortable with. So I just wanted to offer that as to the committee. I'm going to pursue the chair as author of the bill for consideration for the substitute.
I hear you. I'm a little hesitant about, and I understand what your intention is. I'm a little hesitant about if we go ahead and do incorporate that, to the extent that there are inconsistencies between that which whatever the rules the council adopts and that which we put into the statute in other areas of the bill. That's going to cause an inherent conflict in what folks can do and not do. I need to vet that out a little bit. Sure. Get my arms around that a little bit better. But what I don't want to do is, and I see where you're going, and I don't necessarily disagree with the intent of it. I probably agree with it. I just don't want to get in a situation where we're then amending those particular rules. We're adopting these standards by reference, except for A, B, and C, and then that could wreak havoc on that particular management process, and which I know you don't want to do, and no one here at the table does, but I just wanted to step carefully on that. Well, I think there's a way to do it.
We'll the only intent is if the statute hinges on a definition, and that definition can be defined by some extra statutory means, i.e. the council, then what we're really doing is we're allowing the council to determine how this hinges, and that may be what we want to do as a matter of policy, but that's why I raised the issue, Mr. Chairman.
Okay. Mr. Franklin.
Thank you. On the line 160 with the semi-annually and annually issue, could a solution be possibly to retain the words "at least," so that you still have the mandate of the annually, but for those that wish to meet or have a need to meet more than annually, they would be free to do so? Would that be a solution?
You got any strong feelings about that, Ms. Benfield? You seem to be the leader of the semi-annual movement. I'll tell you what, I'm going to go ahead and we'll be making certain changes in the substitute, but certainly when we get to a motion and amendments, if people have got strong feelings either way, we'll certainly allow that to play itself out. Fair enough? Right. That's true. That's not going to happen. If I'm lucky, I'll never be in one of those meetings, but I know that's not going to happen. So, all right, we'll obviously we're going to address that directly one way or the other, either in a sub or an amendment one way or the other. So I appreciate the members' really thoughtfulness this morning. It's very much appreciated personally, and of course the folks who've been here today. Ms. Travis and I will visit on a substitute sooner rather than later, I hope, and we'll have it ready in plenty of time for Monday. So thank you all, and we're adjourned at 12:01.